welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. All right, well, this is going to be a fun episode. So I've got, Jeff, you traveled to Louisville today, which is great. I appreciate that. You came up, but you brought a guest with us. Why don't you introduce your guest here?
Yes, my daughter, Clarissa Roberts, is with us today.
Fantastic. And Clarissa, you're here at University of Louisville.
Yes, I am.
Brandeis School of Law. So tell us about that. You're in your second year?
Yes, I just finished my second year, so got 1 year left.
1 year to go. 1 year to go. Now, I know we were talking about this a little bit before we started the episode, but as far as this goes, now you had already been, you graduated from Murray State.
Correct.
So Jeff, you graduated from Murray, I graduated from Murray, so nice little racer convention going on here. But you had actually been involved with some other law offices as well as you were getting ready for law school. You want to kind of talk about that experience real quickly?
Yes, I worked for the county attorney in Murray for about 6 months, just doing some basic kind of receptionist clerical work. And then I worked for my dad for the last year and a half that I was at Murray State. And for one semester of that, I also interned with a judge in Graves County.
So you kind of knew what you were getting into at the time.
I did.
Outstanding. Well, Jeff, today we're going to talk about the wording of releases. And I know that's kind of a technical thing, and it's something a lot of people may not be aware is going on when they have a claim, be that a personal injury claim or a workers' comp claim, all sorts of different things. I guess these releases come in. But you actually, and the reason we have Clarissa here is you actually wrote an article for something called The Advocate. You want to tell us a little bit about that?
Yes, The Advocate is a publication put out by the Kentucky Justice Association that goes out to the members of that organization. It's a lawyer organization here in Kentucky that is approximately 1,400 attorneys throughout the state that are members of that organization. It's an organization designed for trial lawyers to it advocates and educates both. They put on the best seminars in the state of Kentucky, in my opinion, for training attorneys how to properly represent their clients in personal injury type litigation. They also put out the publication, which is The Advocate, that is sent out to all of those individuals. Plus, they do other things. They keep us abreast of any changes in the legislature, fight for changes in the legislature that will make a person's access to the court system and making sure that we're keeping the individual's right to trial, civil trial, active and keeping that for the individuals in the state of Kentucky.
And you've given some of these actual presentations, some of these seminars for the KJA, Kentucky Justice Association. You've given some of those presentations, but in this most recent edition, you and Clarissa both kind of co-authored an article.
We did. We co-authored an article for The Advocate. It came about, actually, when we were on vacation last fall. There had been some, one of the things that Kentucky Justice Association has is an email listserv that members can ask questions on and get help with some issues that they're dealing with, because most likely someone else has already dealt with that issue to some extent. And it's a great collaborative effort for us there. And there had been some questions posed about different aspects of releases, and I was asked why. I got a text message while we were on vacation asking if I would be willing to write an article for The Advocate on releases, and my daughter happened to be with me at that time, so I recruited some assistants for that article.
That's awesome. So like a lot of other professionals, you're talking shop on vacation. So this just happens to be your world, right?
Exactly. It's I don't work as much on vacation, but I don't know of any attorney that doesn't work at least a little bit while they're on vacation. Absolutely.
Well, so let's jump into this. So in the topic of this is the wording of releases. What is a release? Why is this important?
Well, any personal injury claim, as a general rule anyway, whenever it is settled, there's going to be a release. A release is essentially a contract that is signed at the end of litigation when there's a payment made that will it basically terminates the litigation against the individual that is being released, meaning that the person who is signing the release is releasing, which is a region we have they're called releases, but they're releasing the at-fault party that's paying the money from any further liability for the injuries that the person has received.
So if you and I are in a car wreck, and let's say I hit you, and Clarissa's your attorney, and we all get into a negotiation, it may go to trial, it may not, it may settle, but at some point this prevents you from coming after me 20 years down the road because suddenly you've got another problem that's crept up and you're going to try to relate it back to that car wreck a long time ago. Once this release is signed, hey, it's over. You've got all you're going to get. I've given all I'm going to give.
Exactly. And if the injured party tries to go back in, that case would be dismissed based on the release. As long the court would look at it and say this case is already resolved, and the case would be dismissed very quickly. If someone were to try to do that, generally that doesn't occur, but because the releases are signed and the attorneys representing the injured party tells them, once you sign this case against this at-fault party anyway is over and done with. You can never go back in to get anything else.
And there could be provisions in there for future medical expenses and stuff, but again, other things that are not contained in this settlement agreement, in this negotiated end of the case, are not going to be able to come in. Correct.
Correct.
I guess more or less. There's probably an exception there somewhere.
Well. There's always exceptions to the rule, but as a general rule, whenever you resolve a personal injury case, the release, the money paid, part of the money very well may be for future medical expenses. I don't know that I've ever seen a release that left open, okay, the at-fault party or their insurance carrier still has to pay any future medical expenses incurred. I don't think an insurance company would do that from that standpoint. Now, in workers' comp, we do that frequently.
Exactly.
So on a workers' comp claim, you have that future medical left open. That's a statutory provision there. But in most personal injury cases, once the release is signed, even though there may be some money included in the settlement amount to take care of future medical, the person who is paying the money is not going to be liable for anything after that release is signed.
And I guess this is one of the reasons you don't really want to settle a case quickly, because
Correct.
you don't know what else may be creeping up, what else may be involved. Some people are really interested in, well, just get me some money fast. The problem is you could have a whole bunch of other expenses coming that you're unaware of. And once you sign that release, I mean, the ball game's over, right?
Exactly. And I've had clients come in and within a month of the accident want to start talking about how much their claim is worth. How fast can we get this claim resolved? And I have the conversation with them then that it's much too early to even discuss settlement of your claim. We don't know what all your damages are. I don't know what all your injuries are at this point in time. And I tell people early on in my representation of them, usually actually in my very first meeting, that we're not going to discuss settlement of the case until your doctors tell me you're at maximum medical improvement. In other words, I know at least to some extent, I have a good idea of what your future medical problems are going to be. The doctors have told me there's not likely you're going to have much more improvement here.
Right.
Future medical treatment's going to be this. So I have that, so I can actually properly calculate what damages you have, what's your past medical, what's your lost wages, what is your impaired capacity to earn money in the future,
Yep.
and what is your likely future medical treatment in the future. All of that, along with pain and suffering, comes in on calculating what someone should be receiving in a settlement, or if you go to trial, what you're asking the jury for.
Well, I can see this. I mean, if you're driving down on 641 or something like that, and you get in an accident, you could have a surgery, but you may have to go back for an additional surgery. You may have a few things after you've rehabilitated, if you're going to rehab and things like that, maybe didn't work out right, so you have to go again. If you've signed that release, all of that medical expense is now on you, right?
Correct.
Yeah.
Yes. Yeah. If the release
that's
is
why
signed,
these things are real important. I mean, again, I see a lot of people saying, yeah, we'll get you money fast. Not always in your best interest.
almost always not in your best interest to get your money fast. If you settle the claim before you reach maximum medical improvement, you're probably not settling that claim for the full value of the claim.
Right. Well, and so some cases people want to try to handle it themselves. Yes. And I think as we get into this discussion, we're going to find out some of these terms, some of these issues become pretty complicated. And if you're not familiar with this, you could be letting some people off the hook that you really didn't realize. And I found in this article that there's some surprises in there.
There is, and the article was written for attorneys. So if someone were to go look up the article and read the article, it's very technical. It's inside baseball type stuff.
Absolutely.
From that standpoint. But it also highlights the problems when someone tries to resolve a claim on their own, because there's a lot of technical legal things that if you don't handle those correctly, then you can cost yourself a claim against someone else or cost yourself additional money, or potentially, if you don't do some of the things correctly, you can turn around and have to pay back your insurance company as much money as you've recovered, and potentially even arguably even more. I don't know that any insurance company would seek more than what you actually recovered, but if the health insurance contract is worded certain ways, you could potentially be liable back to the health insurance company. Right.
And these are all those surprises after the fact, because again, you either try to do it on your own, you didn't understand what you were getting into, or you had an attorney who basically was like, okay, let's just get this done quickly, because that's what you want. And maybe I've got a whole bunch of other cases I've got to worry about. Again, being careful in these contract languages and these clauses are going to be very important. Jeff, let's peel this back a little bit. Then I guess the first thing you talk about in the article with Clarissa was the global release. You want to kind of talk about that?
Yeah, the global release in this catches people off guard is if the release. Most people when they sign a release, they read that John Doe. They're releasing John Doe from any further liability. But if the release includes global language in it, that they're releasing John Doe, Jane Doe, and any other person who may be claimed to be liable, then they've just released the whole world in that setting. So if you're in an automobile accident and two people are at fault in causing the accident, so you had a green light, for instance, and you were going through an intersection and two people happened to run through the red light and hit your vehicle. If you signed releasing one of the people at fault for causing the accident, and it has that global language and any other person who might be claimed to be liable, then you've just released that other driver from liability. If you had a situation where your airbag did not deploy, so you have a potential claim against your car manufacturer for a defect in your vehicle.
Sort of a product liability claim.
Exactly, a product liability claim. You've just released that product liability claim as well from that standpoint. So it's those global release languages, they are included in a lot of form releases that I get from insurance companies when I resolve a claim and they send me the release initially. It will have that global language in it, and I have to strike through that, send it back to them, say, take this language out. We're not signing a release with that language. We're just releasing your insured. We're not releasing the whole world.
Yeah, you can't blame them for trying. But as we were prepping for this, you had said you rarely get that first offer that you don't go back and have to modify, because again, they're going to throw the kitchen sink in there and try to get out as quickly and cheaply as possible.
Yes, and I cannot recall off the top of my head anyway the last time I received a release from either a defense attorney or an insurance company that I did not have changes made to the release before I let my client sign the release. And a lot of times it's not really going back and forth with it. Once I make the changes, they usually accept the changes I make. As you say, they're including everything in there for their benefit. Yeah. From that, when I go back to them and say, we're not releasing the world here, they take that out fairly easily. So normally it's just me go back and says, we got to clean up this language. We're not signing it with that. And most of the time, it's not really a back and forth. They say, okay, you called us.
You got me.
Yeah.
So, well, and this is why smart people like Clarissa go to law school, so they learn to watch out for this and understand how to read these contracts. which, again, as I even read the article, I had to go back time and time again to go, okay, now what does that actually say? But I love this this way you started this paragraph. While the statute seems clear, like a lot of things in the law, things are not as clear as they seem. That's just a red flag. But hello, welcome to the law. So.
That's absolutely right. If something's clear, you can rest assured that some lawyer somewhere is going to try to muddy it up a little bit. So.
Well, I tell you, another issue out here with releases, and this is one of my favorite topics, just because I like the way it sounds. I may try to use this sometime. Vicariously liable defendants. What is that?
A vicariously liable defendant is a defendant who is liable for a person's damages because of their relationship to the person who is at fault in causing the accident. Normally, you see that that language used primarily in regard to an employer-employee situation. So if you're driving down the road and a truck driver driving for Averitt Trucking Company or something of that nature.
Amazon, could be anybody.
It could be Amazon. Locally, we have Pascal Truck Lines or PTL. But if that truck driver crosses the signal line and hits your car, well, the driver is the one who's negligent from that standpoint. But not only is that driver liable for your injuries, his employer is vicariously liable, or they're also liable for your injuries that you've received as a result of the negligence of their employee.
In all reality, that trucking company probably has much deeper pockets in terms of available insurance. And if you're in a collision with a tractor trailer, I mean, obviously the damages, the injuries are probably going to be pretty severe. You may not have those resources for that individual truck driver, but that company probably has a lot more resources that you're going to try to go after. So in signing a release, if the victim were to move quickly on this, or the victim's attorney moves too quickly and they sign it improperly, they could actually release that trucking company.
Yes, if you once you sign a release releasing the driver, the employee, that release will release the employer as well. And where you see this come into play is you don't see it as much in a trucking situation when they're driving the employer's truck. What you see occur is sometimes people drive their own vehicle for work duties. You see it with state employees a lot, but even other companies do the same thing. My staff, sometimes they may drive to a courthouse to file a document, and they're doing that on the clock, but they're driving their personal vehicle. So they would, if they're negligent in doing that, then I would be vicariously liable for their negligence. But if they're in a wreck, their own car insurance is going to cover that. And if you've got a situation where I've seen it come back to hurt someone is when the car insurance's coverage is low. So they have $25,000, $50,000.
Yeah, here in Kentucky anyway.
Yeah, 25 is the minimum. If we got $25,000, $50,000 of policy limits, and the person has severe injuries, and that person said, "Well, look, the coverage is only $25,000." That car insurance says, "Look, we'll give you our money. We understand your damages are in excess of our limits. So here, take our $25,000. Let us out of this."
Yeah, but we're out at that point.
We don't want it. A injured party may do that. An attorney who's not aware or thinking through the risks of doing that could go ahead and say, "Yes, this is all the coverage that y'all have, so we're going to go ahead and sign that and then release the at-fault driver." But when they do that, they just release the employer as well, and that's where the damage or the problems can come in if you don't look to who all could be liable as well. And that's one of the things that an attorney has to do when they take on a case is to do that investigation to see, was this person on the job at the time this accident occurred? Is there somebody that may be vicariously liable for the damages as well as the at-fault party, so that I can properly represent my client and I can get my client the best result possible in a case?
Well, and I think that brings up another question. This is obviously why, you've spent a long time doing injury cases. Now, you've done personal injury and you work on workers' comp and Social Security cases, but they're basically injury-related cases. The problem with maybe this kind of case, taking it to a general practitioner, or maybe the person who did your father's will, or maybe your divorce lawyer, they don't really understand or have the experience to understand all the nuances to this language at times. And if they're not reaching out for somebody else to counsel with them, it could actually be a problem.
It could be. I mean, all attorneys in Kentucky are licensed to be able to handle basically any type of case. So even though I do not do will contest cases, technically my license allows me to do that. I don't do divorces, but technically my license allows me to do that because I don't do divorces day in, day out, and never have done divorces in my career. There's I'm sure nuances in the divorce practice that I don't know about, that I would make a mistake if I were to handle that. I would hope that anybody that is handling a car wreck case on behalf of someone else, if they're the attorney, they're going to do the due diligence that they're supposed to do to make sure they learn what they're supposed to learn, or associate with someone like myself who concentrates my practice in doing personal injury work and keep up to date with the personal injury laws and all the nuances of that practice, so that they make sure that they're protecting their client.
And again, it's not that they're unable to do that kind of a case or take on that kind of a case. It's just experience counts for a lot of things.
Exactly.
And you're going to see it better.
Yeah, it does. And even in writing this article, a lot of these issues I knew in my head, that if I settle with the employee, I'm settling with the employer. And the problem with just knowing it in my head, if I go to try to the insurance company and say, look, we can't do this. And I've done it for so long. Sometimes the cases stick in my brain and I remember what the cases are. Other times they don't. And that's where Clarissa kind of come in and helped out a lot on this article for me, is on some of this research that, I knew there's an issue there, but, I needed one of the things I had her help me with is kind of doing some of the research and getting these cases, because when you read the article, it cites to the cases that you need to know, or that talks about the areas of law that that I'm referring to here in the article, in the inside baseball stuff of the article. And that's where having someone who's in law school and who just also happens to be my daughter, so she couldn't really say no. But that's where that helped out, is pulling in the research and helping me get the cases I needed for the citations for this article.
And the citation is basically a reference. Where
the reference to the cases,
yeah.
where the appellate courts have said this is what the rule of law is.
Clarissa, you're doing a lot of research these days, I would think.
Quite a bit.
Yeah, so you're kind of up to speed on where you need to go and what you need to look for and things like that.
Yes, I've gotten pretty good system down now to find things. So.
Good deal. Making your dad's life a little easier, a little easier. Jeff, let's talk about indemnity language. You see that in some different things, and it's probably in a lot of contracts we just sign. I mean, if I go, rent a cabin, there's probably an indemnity clause in there. Can you talk us through what this is?
Well, indemnity is basically when you agree to indemnity or indemnify someone, what you're saying is that you are going to protect that person from anybody else claiming against them. So, to me, I learn better by examples than I do just by technical language. Yeah. So where you see indemnity language in a release for a personal injury claim a lot is in regard to medical bills. So if I'm in a car wreck and my health insurance pays my medical bills, the health insurance contract almost guaranteed has a provision in it that says if there's a third person who is liable for these medical bills, which is the case if someone's negligently causes your injury, then we're entitled to be reimbursed if you recover any money from that third person. And the indemnity clause in the contract is me telling that third person, the at-fault party, that I'm going to take care of the health insurance. And if the health insurance comes back against you and Anthem that's paid $30,000 in my medical bills comes against you and tries to collect that $30,000, I will either pay the 30 to Anthem, or I'll pay you the 30 that you have to pay to Anthem. So it's basically creating the situation where I'm telling the person, or the person signing the release is telling the person that I'm going to take care of anybody else who has a claim against you on behalf of my injuries. And
this is a complicating issue that you really don't know when you're in a wreck and you think, well, this ought to be, they hit me, it should be cut and dry. It never is.
No.
And situations like this come into play. And it's interesting that you brought up the healthcare issue, where your own health insurance might be. Sometimes that does actually happen, where even though you weren't at fault, you may be using your own health insurance for a variety of reasons. That's the conversation you have.
Right.
But then, we'll go back against the at-fault driver and get reimbursed more or less. And so this is kind of these situations, but this is the legal pathway permitting that to happen?
Correct. That's to some extent. And in some insurances, Medicare, for instance, which is federal, and it has federal laws. And as I understand those federal laws, the person who Medicare paid the medical bills on their behalf, the injured party, is responsible to Medicare. But I, as the attorney for that injured party, once I know that Medicare has paid the bills, if I get a medical bill in that says Medicare has paid the bill, or if I know my client is a Medicare recipient, then I have to go to Medicare and ask, have you paid any medical bills for this injury? Because I also, under federal law, I'm personally liable to Medicare. If I don't take care of Medicare and getting them reimbursed, I'm personally liable. The insurance company, that the at-fault party's insurance company, is liable to Medicare. And if there's a defense attorney, that defense attorney could be potentially liable to Medicare as well. So in those situations, you pretty well guaranteed I'm going to make sure that Medicare gets taken care of. Yeah. And the defense attorney or the insurance company is going to make sure they've got that indemnity language in the release so that they protect themselves and protect their insured person, to make sure that they don't have to come back and pay any more money out on that claim.
Hey, we satisfied our contract. We've done what we were supposed to do.
Exactly.
Yeah, and that makes sense. And this is, if you've ever been in one of these accidents before, you may have heard the term healthcare lien, and that's probably getting into a little bit about what this is, right?
Healthcare lien. Term we use in the legal field a lot is subrogation interest. Yep. Kind of the same situation from that standpoint. And the problem with indemnity language in the release, first off, if you're not represented by an attorney, you probably have no idea what indemnity means. And signing something, any kind of contract, signing something where you don't understand the terms of the contract is something you should never do. You should read the contract, and if you don't understand the contract, you need to take it to a lawyer to understand that contract before you sign the contract. But even if the person does, and they realize, and the insurance company says, look, you've got to pay back. Anthem's paid $10,000 your medical bills. You've got to pay Anthem back $10,000 from this settlement. Or even if they say, we're paying you our $50,000 limits, but Anthem has $10,000 lien against this, so we're going to pay you $40,000 and we're going to pay Anthem the other $10,000. And the person said that's fine. The problem with indemnification language in a release is kind of like the global release language. You can actually end up losing other claims. Yep. The same situation as we talked about with vicarious liability of releasing releasing one party that and there's somebody else that could be vicariously liable, can come into play on the indemnity language. Is if you agree to indemnify, in that indemnity language is global, it's fine if you limit the language to, we will indemnify you if any medical provider and or health insurance carrier comes back and seeks money from you. Yeah. Then you're limiting what you're indemnifying to medical. But if you say anybody who has a claim,
that's that global release.
That global, if we would indemnify you against any claims from anybody that's had to pay us money, and then you turn around and you try to pursue someone else that is secondarily liable for that. You've actually, because of that indemnity language, you've just released the claim against the secondarily liable person. It's
self-inflicted. I mean, if you sign the document, I mean, and that's why it's so dangerous.
And basically, what you've done there, and circuituity of litigation or something of that's the what they call it in the appellate cases. It's decided this, but essentially, if and since we got three people here, I'll just use it as an example. If Clarissa is working for me or driving my vehicle, she negligently hits you, so you have a claim against Clarissa. You have and I'm secondarily liable for Clarissa. If you tell Clarissa you're going to indemnify her against any other claims against that, well, if I have to pay you money because it's secondarily liable situation, then I could potentially have a claim against Clarissa for what I have to pay out to you.
Right.
And so if you agree to indemnify her and then you come after me, well, I can go after Clarissa. You've got to pay. So basically what it is you got to pay your own damages in that regard, because I have the claim against Clarissa and you've assumed
her money around the table.
You've assumed her liability and they said, we're not going to let you do that.
Yeah.
So, so you've released by signing that indemnity, even though you reserved the claim against Jeff Roberts, in that release, that indemnity just released.
And that's where we're coming back to that statement at the beginning of that paragraph. It's not always what it seems, and that's where it gets tied up.
Correct.
And let's be honest, there is an art to the practice of law, and sometimes people will try to slip in these clauses in different areas of the contract. And you've got to have somebody that really knows what they're doing. And again, that's the experience that you bring to the table, is that you've done this hundreds and thousands of times, and it's something that you know what to look for.
Yeah, exactly. And I'm using that from the car wreck standpoint. You see these a lot in a negligent security situation, where if there's a fight that breaks out at a bar and the bar didn't have the proper security, they're at the bar for that. Well, the person who started the fight is the primarily liable person, and the secondarily liable person is the bar owner. And so if you sign the indemnity with the person who started the fight that's primarily liable, with that indemnity language, you just released your negligent security claim basically against the bar at that point.
Wow. I mean, that can sneak up on you quickly. Part of this article talks about the problem, I guess, or the risk of naming the insurance company in the claim. Where does that come in? I would think they would normally be added to that anyway.
That's a pet peeve of mine. Because how
do you really feel about it?
Some attorneys routinely allow clients to do that, and even when I'm, an injured party can have a claim against an insurance company for bad faith in how they've handled the claim, and if they didn't settle the claim the way they should have in a timely fashion. And if you include the insurance company's name on the release, you've just released that potential bad faith claim there. But even if I'm not going to pursue a bad faith claim, if the insurance company's done everything they're supposed to do, they aren't the person we're pursuing the claim against. The person we're pursuing the claim against is the at-fault driver of the vehicle. If I filed the lawsuit, it's not going to say Geico Insurance is who I'm suing, unless it's an underinsured case potentially. But it's going to be the at-fault driver who's going to be the person that's going to be named in that lawsuit.
Right.
And the insurance company will almost routinely include their name in the release for the very fact that they don't want somebody to come back in and ever say, no, this was bad faith. We want to pursue a claim against the insurance company. Or even if the insurance company, I think, you could come in with a fraud situation, but there's been a fairly recent case where the insurance company originally said there wasn't coverage there. Is an underinsured motorist situation. They said there wasn't any underinsured motorist coverage there. And if you had the and if you have a situation where that comes in and you've released that insurance company,
they're scot free.
Exactly. And sometimes you have, I've seen this occur, and I didn't know the attorney, but I know it's one attorney made a big mistake in this some time ago. It's been several years ago now, where the at-fault driver and the injured party had the same insurance company.
Mm-hmm. Oh, yeah.
And so if both of you have Farm Bureau insurance company, well, you may have underinsured motorists, and if they got $25,000 of liability coverage on the at-fault driver, and your damages are $100,000, and you have $100,000 of underinsured motorists, if you put Farm Bureau's name on that release, and you sign that with the at-fault driver, you've just released Farm Bureau on the underinsured motorist claim because you've released them.
Right, and we'll come back to that toward the end of this session, because I mean that's a big deal. And in fact, underinsured and uninsured motorist coverage is something you're paying for already.
Correct.
So now you've said, even though I've been paying for you, I'm signing this, which means you don't have to stand by your side of the contract, which is amazing. But I'm sure it happens.
Right.
I'm sure it happens.
Yeah, and that's something that 10 years ago, 15 years ago, insurance companies sometimes balked at taking their name off of the release. Mm-hmm. Now, they always would take it off if you had an underinsured motorist claim. They would say, okay, yeah, we understand that. But sometimes they would balk on taking their name off the release, but they never could give me any legal authority as to why their name should be on the release, and ultimately they would take it off the release.
It was company policy.
Yeah, exactly. And, nowadays, once I go back and say, we're releasing that fault party. We're not releasing the insurance company. And normally what I'll go back and say, if you want to release for the insurance company, pay us more than just policy limits in this case. And then if the insurance company wants released, they need to buy that release just like the at-fault party's buying their release. And they say, okay, we'll just take our name off of it instead of giving you more money or your client more money, my client more money. But that's something that is coming about more and more. I don't think Kentucky has ever addressed the situation as to whether that's bad faith, but I know some states did that. That's one of the benefits of having a law student do research for you. But there are some states that have actually said that the insurance company insisting their name be on the release is bad faith on behalf of the insurance company.
And the issue with bad faith, that's a whole other area of law. But I mean, realistically, if the insurance company drops the ball somewhere and says, hey, we'll just keep quiet, nobody will know the difference, we're going to send this check out and we'll just hope nothing comes back. If you do have them on there, then you release them from a potential bad faith claim, which would be a claim where someone like you, Jeff, could come back and say, hey, wait a minute, you guys didn't do what you were supposed to have done. Therefore, there's added liability here and possibly some extra money for the client.
Yeah, I mean, if they committed fraud,
into big numbers. I mean,
exactly, it can be very much so. But and it just adds, if they have committed fraud, you very well could undo the release in that regard because of fraudulent their fraud in obtaining the release from that standpoint. But a lot of times, if it's just negligence, somebody. It wasn't an intentional act that they
slipped this one through.
Yes, the agent didn't look at something they should have looked at, and had a different policy number for this other car that they weren't, and they didn't catch it. Then you very well could end up causing your client some additional recovery in that regard.
Let's move on then to these confidentiality clauses that come into these. And again, the whole nature of this discussion is just the fact that this stuff is so daggone complicated that you've really got to have someone with experience who knows what they're doing to go through these documents with you and to really explain these individual clauses, these paragraphs, this terminology.
Right.
Vicarious liable defendant. Again, I'm going to go back to that. That's it's a great term to use, but if you don't know what it is, I mean, why would you sign it? So confidentiality, I mean, a lot of the settlements that you see even were settled for a confidential amount, and nobody necessarily wants to have that number out there for a lot of different reasons. But there's also tax consequences, which is a whole other area I didn't even think about. Jeff, you want to kind of explain some of this for us as well?
Yes, there was a case several years ago now where Dennis Rodman, if you're a basketball fan, people know who Dennis Rodman was.
Chief negotiator with North Korea, I think.
Yeah, at least he tried to be. But he had injured a photographer, I believe it was.
Sure.
I don't remember all the facts of the case, but there was an injury in a suit was filed. And part of the resolution was a confidentiality clause in there, and basically the tax court come in and said a large portion of this settlement was for the confidentiality clause, not for the personal injury of the person, but for the confidentiality clause. Personal injury damages are not taxable, but confidentiality, what's paid for the confidentiality clause itself is taxable.
It's almost like tax on a service or something at that point, right? I mean, is it similar to that? I mean, it's not really. It's not conceptually, I guess. It's not really part of the injury claim. Right. It's just it's a clause that you're putting in here.
Exactly. And so they basically, the tax court apportioned a good chunk of that settlement as for the confidentiality clause, and that caused that settlement, that portion of that settlement to be subject to taxes by the federal government. So if you have a confidentiality clause in an agreement, it needs to be either a mutual, both parties want this to be confidential, and therefore there's nothing being paid for it. It's the mutual agreement from both parties to keep this confidential. I don't, and that's a legitimate position, especially when your client is getting a large sum of money.
Right.
I won't, when I recover, $1 million, $2 million for a client, a lot of times I want that to be confidential. Right. I don't want someone to know about that become public knowledge, because people come out of the woodwork.
Well, it's amazing how many third-generation cousins who were your best friend back in third grade suddenly want to rekindle their friendship with you.
Exactly, or your friend who sells some sort of type of insurance is going to come knocking on the door when they find out that you just received a large sum of money from a settlement in that situation. So it protects my client for that dollar figure to be confidential.
And I guess at the same time, if a large settlement or a large verdict is being paid out, well, a settlement probably is being paid out, the insurance company may not want to disclose so that everybody knows, hey, they're willing to pay this much. So they may say, hey, we'd like this to be confidential.
Correct. Exactly. You can see that in that situation as well, where when they settle, sometimes they think, well, if it becomes common knowledge that we settled this, it's going to cause other people to bring these type of claims. So we want it to be confidential. So a lot of times the confidentiality language is mutual. I want it to be confidential so it protects my client.
Right.
And they want it to be confidential so it doesn't cause other people to pursue claims against them from that standpoint. So most times, if you're just doing the dollar figure, that's easy to put the mutuality language in there. Yeah. Or if it's not a mutual, then you need to put into the contract or the release the dollar figure that's being paid.
You need to assign some dollars to it.
Yeah, so $1,000
is taxable.
Yeah, it's right. If you say $1,000 of this money is being paid for a confidentiality clause, that $1,000 is now subject to tax.
Right, and it could be $1, it could be $1,000, it could be $20,000, it could be whatever.
Right,
but again, that's negotiated between the two parties.
Right, exactly.
Okay. So, PIP insurance, and this is fun. PIP insurance in Kentucky is personal injury protection, and most of the time you've got this available if you're in an accident. There's up to $10,000 worth of funds that are readily available for you. But how does this come in with a release? What are we doing here with PIP?
What was occurring is when someone would settle a case with the at-fault party, and we've talked about PIP, I think, before and some things, but PIP is part of the no-fault law in Kentucky for car insurance. When you purchase car insurance, you get personal injury protection or PIP benefits that covers your first $10,000 of medical and or lost wages at a minimum. $10,000 is the minimum coverage for PIP that they can write in Kentucky. Yep. You can actually purchase additional coverage,
that's right.
Additional PIP coverage as well. But if you settle with the we were seeing sometimes is people would settle with the at-fault party before they used up all of the PIP money, and then the PIP insurance company would come back in and say, well, you signed a global release type release, so now we don't have to pay, even though you've only used 5 of the 10,000 and you're still getting some medical treatment. We don't have to pay that other $5,000. And Kentucky went through the court system, and there were some in there that you needed to include in the release that the money is exclusive of PIP, so you don't have to pay PIP back, number one. And you still need to include that language, but all settlements technically are exclusive of PIP in Kentucky unless you say it's inclusive of PIP in there. And then they've come back and basically said that even with the global release, because it's not a personal injury, it's a contract type situation there, that the courts have essentially protected the injured parties from this language. If they don't get an attorney to protect them, they've kind of taken the step.
They'll step in and help this time.
Releasing that fault party does not release PIP from having to pay in the future.
Well, this may be one of the only times I've ever said, they said we're from the government, we're here to help, and you could actually believe them. So that's a good thing. Let's talk about UIM claims, Jeff. And you want to explain again what that is, and then where this signing of a release comes into play or conflict. UIM is short for underinsured motorist coverage. And whenever, again, in Kentucky, it's part of the insurance contract. Now, UIM coverage is not mandatory coverage like PIP is mandatory coverage. They cannot write a contract in Kentucky that doesn't, a car insurance contract that doesn't have PIP coverage. UIM is optional coverage that everyone should make sure they have on their vehicle. And a lot of it, actually.
Yeah, exactly.
It's cheap.
It's one of the cheapest types of insurance out there, partly because it's not mandated, so they have to have it at a rate that people want to buy it, otherwise people aren't going to buy it.
So if I pull out my insurance card right now and I flip it over, I probably see, among other things, UIM, and there'll be some numbers there.
Right. Some companies will put them UIM together.
Yeah. Sometimes they sell them separately.
Yeah, is uninsured motorist coverage. UIM is underinsured motorist coverage, and sometimes they are together. Sometimes they're separated. In that some insurance cards, they use a coding system, so you can't really tell. It's like A coverage, B coverage, C coverage, and C coverage is UIM coverage or something of that nature. But you should look and talk to your agent to make sure you have underinsured motorist coverage. And what that coverage is, it protects you, it protects your family members, other people in your car. If you're in an accident and you're not at fault for the accident, and the at-fault party insurance is not enough to cover your damage. So if they've got the minimum coverage of $25,000 and you have to have a surgery on your neck because you had a herniated disc from this, and your damages are substantially greater, your medical bills are more than $25,000 in that regard. And so even if you got the $25,000, that goes back to your health insurance at that point, and then you're out of your own pocket for co-pays and deductibles and things of that nature over and above at that time. So having the underinsured lets you get compensated from your own insurance company for those damages above what the liability.
And that always confuses people. Why would my own insurance? Well, it's something you're paying for. It's part of your insurance contract. It's part of your fee structure. The reason you're paying what you're paying is probably that is included somewhere in your policy. And so don't be afraid to use it. I mean, especially when you need it, especially if someone hits you and they don't have enough insurance coverage, you're protecting yourself. And that's one of the reasons you ought to have a lot of this coverage.
Right, exactly. You should have a lot of that coverage for yourself. I mean, it protects you and protects your family. Yeah. And that's the reason we have insurance. Right. The reason we have health insurance is, I don't plan on going out in my backyard and tripping, falling, and breaking my leg, but it could happen.
It could happen.
And it's there. I don't intend to have be negligent and cause a car accident, but it could happen. And if it happens, I want my coverage and my limits to be high enough to take care of anybody that I might injure. But by the same token, I know not everybody has high limits, and I want to protect myself and I want to protect my family more so than, I guess I'm selfish to some extent, but I'm much more concerned about protecting myself and protecting my family than I am other folks as a general rule. And I don't want to hurt anybody, but that's my priority from that standpoint, and that's where UAM coverage comes in. That lets me do that.
And so where do the signing of releases come into play or conflict?
Whenever you accept the liability limits, that brings into play and you plan on pursuing a UIM underinsured motorist claim, then there's a certain procedure you have to go through, because the underinsured motorist, kind of like health insurance, is paying me when somebody else ought to be paying me. The underinsured motorist company, if they pay me damages for the injuries I received because of somebody else's negligence in a car wreck, my insurance then has a claim against that at-fault driver. Mm-hmm. So if I sign a release releasing that at-fault driver from any further liability, technically that's operating as a release of the underinsured motorist claim, carrier's case against that at-fault driver, because they're going through me to get to that at-fault driver from because they're paying me, so that's what it is. And
so basically, you're on your own at that point again.
Yeah, if you don't go through the proper procedure, and there's a procedure in Kentucky that it started off from a Supreme Court case, it's now statutorily required. And if the injured party doesn't go through that proper procedure, then they are giving up their underinsured motorist claim when they sign that release for the policy limits of the at-fault driver. So, and it's essentially the process you have to go through is you have to send a letter, certified mail, to the underinsured motorist insurance company, letting them know that the tortfeasors offered their policy limits, that you're accepting those policy limits. It can't be conditional. You can't say we're considering accepting it. You've got to say we're accepting those policy limits, and give the underinsured motorist carrier 30 days to make a decision on whether they want to substitute the payment of the liability carrier so that they can protect their claim against the at-fault driver, to be able to seek money against the at-fault driver for what they have to pay me, or they can waive their claim against the at-fault driver and allow me to allow my client to take the at-fault driver's liability limits and release the at-fault driver from any further liability. So essentially, it's just you give them notice, and then they get to make the decision. Okay, we're not going to pursue the at-fault driver. You can take that money, sign that release, or we think they may have some assets we want to pursue. So here's their $25,000 limits, and you can't release them now. We're substituting that payment because we won't be able to go back against them if we have to pay you over and above this $25,000.
Well, like everything else, once that document is signed, it's pretty much done.
Yes.
And so if you sit down and you rush through these documents and you sign stuff you're not clear on, there's a good chance that you're signing away some rights. You may be signing away some substantial funds that are out there that you deserve. And again, I can't stress this enough. If you're in that kind of a situation, you really need to sit down with an attorney.
And exactly, and this where I see the underinsured motorist issue coming into play from that is people who've settled their claim against the at-fault party. Sometimes the damages, the insurance company for the at-fault party knows their coverage isn't sufficient, and they go to the person and say, "Here's our liability limits," and that person is sitting there thinking, they're offering me their liability limits. Why would I want to give an attorney a portion of this money? And what they've ended up doing, and I've had people come to me and talk to me several times, and then they've given up their underinsured motorist claim without realizing it, and they could have got another 50, another 100,000, or even more than that in damages. But they saved a couple $100 or even a couple $1,000 of attorney fees. They thought they were doing the right financial thing. This is smart financial move on my part to take this and not pay any of this to an attorney. And then they ended up costing themselves several thousands of dollars, if not hundreds of thousands of dollars.
And it happens, I would think, fairly commonly.
I've had that conversation with, in my career, I've had that conversation with a lot of folks is, unfortunately, by signing this without going through this proper procedure, you've just given up your claim. And I've had them come in and they've had $100,000 of coverage and would have easily gotten that $100,000 because of the damages that they had received.
It's a little paperwork.
And they come in and, you've got the coverage. And then, well, I've already settled with the liability carrier. And it's like, you've already settled with the liability carrier. And
why?
And did you go through this procedure? No, they just, the agent said that they would, or the adjuster said they'd pay me the money, sent me the check release. And nobody ever told me about the underinsured motorist carrier. That's the reason you go to an attorney to represent you, because that insurance company isn't representing your interests. They're protecting themselves and they're protecting their insured, and they don't care about your underinsured motorist claim.
And that's how they get those big buildings, those big shiny buildings.
Yes.
So anyway, hey, Jeff, I really want to thank you for your time. Yes. This is complicated stuff. These are things that people just don't think about because we don't know about them. And, as you wrote in that one paragraph, it's not always as clear as it seems. Yeah. And there's a lot of liability out there if you're not careful. Yeah. And that's unfortunate for people, especially when the accident wasn't their fault to begin with. But once again, I really appreciate your time. Clarissa, it's a pleasure to meet you. Thanks for helping your dad on this article. I know your dad and I talk fairly often, and sometimes it's a contest between the two of us, whose heart and whose chest swells up bigger when we're talking about our daughters. But I really appreciate it. I know he's a big fan of yours. So good luck at U of L.
Thank you.
And wrap it up and get out there and start helping some people. So, Jeff, thanks for your time. I appreciate it. One more thing?
Yeah, one more thing before, because I talked about Clarissa in swollen chest moment here, but I talked about Clarissa.
Proud dad moment.
Exactly. I talked about her doing the research on it. She also helped edit it. I've been doing this 27 years. She's not really doing it yet. She's just in law school, but she's already a better writer than I am. And so a lot of the editing and the language in here was her making it better and sound better and much more clear and understandable and for me. So I appreciated her help on this.
Clarissa, nice job. Nice job. All right, my friends. Hey, if you have any questions about this or other topics, you'll have some contact information for Jeff in just a second. But that's a wrap for this episode. We appreciate your time and thanks for listening. We'll talk to you again here in about 2 weeks. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.